This is the Maryland Tenants Bill of Rights, which went into effect October 2025. Again, these are looking at from the perspective of a Virginia agent working um, in Maryland. So let's do this. Pin. Okay, got it. So I'll just scoop down here to um, the rental applications. The first thing is the landlords who rent five or more units can only keep a maximum of $25 for the app fee. Now you'll see a lot of them are $50. Say, well, how can you do that? Well, because that's the application fee. The other may be a background search and that kind of thing, which may cost more money. Most of these are charged through a third entity. It's not usually the landlord collecting a check, but Um, if a landlord charges more than 25 and their costs were less than the amount charged, they must refund the portion that was not used for the application related cost if that person is denied. And it must be made within 15 days of the tenant moving into the unit or the landlord of the applicant gives notice that the applicant will not rent the unit. So application expenses may ask the landlord for a list of the application expenses. The list must include monetary amounts and descriptions of each expense. I just don't see this process being less than $25 for anybody. So you're going to hire someone to do it for you. Those probably need to update those numbers. Tenant screening report. Some landlords may choose to accept a tenant screening report prepared by a consumer reporting agency within the 30 days before application is submitted. Prepared by a consumer. If a landlord accepts such a report, they may not charge you an application fee. And that's why a lot of these applications are done online. And so the landlord's like, I'm not in the middle of it. That's kind of what's going on. Pet policies. They must include a written copy or summary of their pet policy in the application. Must include breed or weight restrictions, any limit on the number of pets allowed, any required fees, including upfront non-refundable pet fees, refundable pet deposits, and monthly pet fees, vaccination requirements, liability insurance, and additional requirements. Assistance animals. Assistant animals are not pets and are always allowed, regardless of your landlord's pet policy. An assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or provides emotional support that reduces one or more identified effects of that person's disability. And this is the one where a lot of folks are like, okay, how do I know that's happening? And if you can't tell by looking at the person that they have a disability that would require an animal, then you can ask them for, I need some documentation that you are therapeutically in need of this animal. There's no additional application fee or additional security deposit for the assistance animal. Your landlord can charge you repair fees if the animal causes damage to the unit. Landlord may ask for information allows them to evaluate it if your disability is not obvious, what I just said before. And this is the code in Maryland. So number two, leases and tenancies, written lease requirements. A landlord who rents five or more units in Maryland is required to use a written lease. That's interesting that it's at five or more. A landlord who rents four or fewer is not required to use a written lease. If the landlord does not use a written lease, tenancy is presumed to be 1 year. So there's an assumption of 1 year once they move in without a lease. I just don't know how you enforce that. But for the tenant, they got to have a statement of the condition of the property, explanation of how the utilities work, a receipt of your security deposit, a copy of the most recent version, which is this one of the Tenants Bill of Rights, and contact information for the landlord or the agent authorized to receive notices and service processes on the landlord's behalf. All right. It cannot include anything that requires you to allow the landlord to confess judgment, agree in advance to let the landlord win a claim. In other words, you can't take me to court. Nothing in the lease can say that and we're used to that type of language. If you think about all the stuff that we sign off when we get updates on our phones. In there, in those user agreements, UAs, there's usually a line that says, and you can't take us to court because you're agreeing to use our product. So in a lease in Maryland, a landlord can't force you to say, I won't take you to court. Anything that says you give up your legal rights is, cannot be in that. Any provision that shortens any notice period required by law, any provision or anything else that obviously is prohibited by law. The challenge for that is a lot of times the consumer doesn't know what the law is, and that's why it's important for them to use an agent. If there's automatic renewal, it's separate from other parts of the lease, and it's got to be signed by the tenant to say, yes, I am agreeing to a automatic renewal. For to end the lease, a written lease with a stated term, the landlord must give you at least 60 days. So for month to month, the landlord must also give you 60 days. For year to year, it's 90 days. If the lease is for a whole year, then I got to give you a 90-day notice before we tag on again. That's for the landlord. For the tenant, leases with a stated term, month-to-month tenancy, and all others, you must give at least 30 days. So that's the difference. You'll hear the number 60 and 30 thrown around in this tenant world. Just make sure you understand the landlord has 60 days to give notice. The tenant has 30 days. Unless it's year to year, then they also have 90-day notice. Okay. And then in Maryland, in Baltimore City, tenants are required to provide 30-day notice. Now, I think I mentioned this in the earlier video on some of the differences between Maryland and Virginia. And again, these videos are for Virginia agents who practice in Maryland as well. And that is, you notice here, this requirement does not apply in Baltimore City. There are a lot of other things in Maryland where it will say, well, in Rockville, it's this way, or in Montgomery County, it's that way, or in this town, it's this way. Maryland allows counties to pass laws and require forms and regulations on rental policies. Virginia doesn't do that as much. So, for instance, Loudoun County tried to pass a bill that said you must disclose that the Dulles Airport is within a certain amount of mileage from your house. It was a county form, and the legislature said, no, you can't do that. So they had it, but they couldn't enforce it. And then, of course, the next year, the legislature said, okay, well, we should have that too. But in Maryland, and at the Maryland Realtors Association of Realtors website, anytime you're doing something outside of PG, Prince George's, and Montgomery County, which we have those libraries in our forms, you should go to mdrealtor.org and look up the forms there. This is assuming you have a membership there, which to operate in Maryland and Virginia, in Maryland, you should have joined MAR, Maryland Association of Realtors, and GCAR, the Greater Capital Area Association of Realtors. Ending your lease early due to abuse. If you have experience, you can end your lease early by giving notice. Copy of a final protective order, a peace order issued by the court. So they can't make this decision on their own. They have to go to court to be able to say, I got to get out of here. A copy of the report from a qualified third party, doctor, psychologist, social worker, and an advocate from a domestic violence organization. I think it's quite understandable why that's required. You have 30 days to move out once you give that notice. If you move out in fewer than 30 days, you must give your landlord a signed, notarized, and written notification you've moved out. The notification must be hand delivered or sent by first class mail. Email doesn't work. If you do not give your landlord this, you will be responsible for the rent for the full 30 days. So while there's a lot of protective items in this Bill of Rights, there's also pointing out what your requirements are as a tenant. If the lease ends and no one gives notice, neither side gives notice, your lease may automatically renew or become month to month. So you're living there and the tenant says, well, I don't know. So, well, then it's going to go month to month. Lease common tenancies like week to week, year to year, or farm tenancies have different notice requirements. And here it is in the law, but for our all intents and purposes, if you don't give a notice, then it automatically renews and goes month to month, depending on the terms of your lease. Kind of hard if you don't have a lease in place. And that's where people that want to do it on their own, be a rent by owner, They run into issues when they don't understand how this works. Rent is due as your lease states. If you pay rent late, your landlord can charge a late fee, but not more than 5% of the late rent amount. Okay. Your landlord must give you a receipt of your rent payment if the rent payment is in cash. Rent increases may only increase your rent when your lease is renewed, not in midstream. They must tell you in writing 90 days in advance of any rent increase. So let's say it's June, March, April, May, June. They'd have to let you know in March that your rent's going to go up in June when we renew. There again, these local jurisdictions may limit how much rent can be increased. So you got to check with the local county. Your landlord can provide notice of rent increase by email, text, or electronic tenant portal. Utilities. Um, this is just saying that, who's responsible for it and that so that the tenant understands your lease may have utilities included, but maybe not. Be aware of it. If your lease requires you to pay utilities, your landlord must give you copies of the monthly utility bills. That's if it's going through the landlord, paid directly to your landlord. Um, at the beginning of each lease term, give you in writing the total utility cost billed to the landlord for the previous year. So they can't just say, hey, I need $50 from you every month. They got to show you how much they're getting charged and the annual cost. Some landlords in larger buildings use a ratio utility billing system. Don't even ask me how to calculate that. But they got to tell you how it works, provide you copies of the last two utility bills, and describe how they calculate your bill. Security deposits. A landlord may require to have one. You may offer a larger security deposit if your rental application will be denied based on credit or rental history, but it can't be more than 2 months. And your security deposit may be up to 2 months if you signed your lease before October 1, or if you qualify for utility assistance from the Department of Human Services. Okay. This is it's just showing you what the security deposit is. I think most agents know what that is. Payment rules, just how the landlord is supposed to handle the money. Landlord may not require you to pay more than the sum of the first month's rent and the security deposit before you move in. Okay. The landlord must keep your security deposit in an interest-paying bank account. They must give you a written receipt included with the written lease, and the landlord must inform you about your rights and the landlord's responsibilities relating to the security deposit when you pay the security deposit. Move out inspection. The landlord inspects the unit for damage. It may reduce your security damage. This is why it's important when you're moving in or when your client's moving in, they do a good walkthrough. Take pictures, make notes, put it in their file and send it to the landlord. And so when they're moving out, they can document, hey, no, that crack was always there. That smashed window was always there. Hopefully not, but if you want to be present during the inspection, you must send your landlord a certified letter at least 15 days before leaving. I want to be there when you walk through. If the tenant and the landlord have had a struggling relationship, I see that's when tenants want to go in and walk through with them. Okay, saying the letter 15 days before says you plan to move, when your move out date, and include your new address. At the end of your tenancy, your landlord must give you a written list of any charges deducted from the security deposit, and they must return the rest of the deposit with interest within 45 days. So a lot of folks, I moved out, I want my money. Well, you may have 45 days. So when they're moving from one apartment to another, they probably need to finance that with other cash. Don't count on the money from the deposit to cash your next move. Here are the allowed deposits from the security deposit: damage, unpaid rent or utility bills, costs or fees from eviction. So usually it'll just be these first two. If the deposit is not returned on time, if the landlord doesn't list it within 45 days, they may lose the right to keep any of the deposit. And you can sue the landlord for up to 3 times the amount, which gets pretty pricey in today's world. Every rental property must be fit for human habitation. When you're reporting, report to your landlord in writing phone calls and text. I don't know that text counts, but I would say email, maybe mail them if something's wrong. You can also reach out to your local code enforcement agency and request an inspection, a citation, or notice. Violation of a notice is considered written notice to the landlord. Mold specific requirements. Landlords must test for mold within 15 days of receiving written notice. If mold is found, they got 45 days to fix it. If it can't be fixed within 45 days, it must be fixed within a reasonable time frame after the mold is found. Reasonable time frame is always a questionable thing. Well, what is reasonable? And they got to keep you informed. Um, if they're coming to fix your house, they got to give you 24-hour of advance notice, and you must provide landlord with access. This has always been amazing to me when tenants want things done and then they won't let them in the house to do it. That doesn't work for me. Well, that might be when the repairman's available, and now it's pushed on for another week or another month, and the tenant gets all upset because they didn't want to be um, helpful in getting them in there. So if you got tenants, remember to tell them that. And then if they're not fixed in a reasonable amount of time, they can file a lawsuit with the district court, refuse to pay rent, and use the issues as a defense if the landlord sues you for rent. File a rent escrow case, which allows you to pay rent to the court instead. I would submit one or three. I wouldn't go number two, because then it's he said, she said on whether that was right or not for you to withhold the rent. I would do a rent escrow and say, I'm paying rent. It's just it's going to the court. So then the landlord is like, oh, the court's involved. So I got to make it's there. I just got to do right to get my money from the court. Um, lead paint, I think you understand that. There's got to be notices given. Evictions. The landlord may start the eviction process by filing a case in the district court. This is going to be probably county by county, so keep that in mind. It's not always here are the evictions for the state of Maryland, and all of them got to follow it. It's a little bit different county by county. There's a court process required. Your rights in the court, notice before eviction. I'm just going to let you take the opportunity to read that. And there again, here's the one where the county is different than the state. Um, Now, constructive eviction is when your landlord doesn't fix a major issue that stops your use and enjoyment of your rental unit. So it's almost like a reversal eviction. So this is interesting. And always they say before you move out, consult with an attorney. I mean, this is thousands and thousands of dollars that people are responsible for when they're having issues with rent. They need to make sure that they are getting legal counsel, because if you stop paying rent in this area, I mean, 3 months, you're behind $7,500. If you're not putting that money aside somewhere, it could really come back and bite you. Tenant right of first refusal. The right of first refusal means you get the first chance to buy the property you rent before the landlord sells it to someone else. When does it apply? When you are named a tenant on the lease, you have lived in a rental property with 1, 2, or 3 units for at least 6 months. Your landlord plans to sell the property or receives an offer to buy it from a third party. So the idea for landlords is if they're going to sell their rental property, they should let the tenants know early on. Don't wait till you get an offer and then say, oh, by the way, okay. And then, because then that can back things up. Here's the backup. A tenant has 30 days from the date of the notice to make an offer. So if the landlord waits, I just got an offer today. It's the 15th of the month. I want to close the 15th of next month. The buyer has 30 days to respond and to make an offer. So really, you got to make it longer than that. If you make an offer with the same or better terms than those in the notice, your landlord must accept it. Landlords need to understand that. Selling rental properties is not going to be as not as much of a clean sweep as selling your own individual property. And then if you decline to make an offer, your landlord may sell the property to a third party. So you the same or better terms means you've got one in hand. So this would be an interesting furtherance on this to understand. Because if I'm letting you know I'm going to sell it and you give me an offer, I don't know if that's beating the other offer out or not. It'd be like DC. DC, you kind of wait till there's an offer in hand, then you let everybody know. See, here's the thing. Some local jurisdictions may have their own laws about tenants' rights of first refusal or the opportunity to buy or rent. But it is there in Maryland now. And then these are the prohibited acts on discrimination. I think these are pretty common now across the DMV area. Retaliation, a landlord cannot retaliate against you. Making good faith complaint about a violation of your lease, violation of the law, filing and participating in a lawsuit involving the landlord. These are things that if you do this as a tenant, the landlord can't retaliate. Okay. Retaliation may include actions such as threatening to file a lawsuit, threatening to notify law enforcement about your immigration status, increasing the rent, decreasing the services to you as a tenant, failing to make necessary repairs. And I need to pause this just for a second. All right, so then resources for tenants are here in the bottom. Council, court, self-help centers, things like that. So this was quite a bit more extensive than the one in Virginia. Make sure that the tenant sees it, but with every lease, this must now be included. So if you're dealing with tenants, make sure this is part of what they're receiving. That is the tenant Bill of Rights. Did you have any questions, Vernon?
Hmm.
I think they're pretty straightforward.